you, counsel.
You can just move that exhibit, please, and the state can do rebuttal.
Ladies and gentlemen, defense counsel stated that the state has not met its burden of proof. And then they didn't mention a single element. Not one of the legal requirements you have to take a look at here. Not one of them. We showed and proved that the defendant caused the death of the victim. We showed he did so with intent to kill. And defense counsel stated, oh, well, he's not a cold-blooded killer because why didn't he shoot 17 times? That's not the law. The law is whether or not he shot with intent to kill or practically certain to cause death. He took a gun that he's trained on, that he knows what will happen. He points it at the head of another individual, ladies and gentlemen, and he pulls the trigger and he puts a bullet in the victim's head. He says he's not a killer. He killed someone. That's what this is about. Ladies and gentlemen, Theodore Cameron didn't say he was a cold-blooded killer. What he said was what the defendant did was cold-blooded. He didn't mention during any time about the defendant looking shocked or looking scared or any of that. Not when he's talking to the police. Ladies and gentlemen, when he was talking to the police in that 911 call, what was he doing? Begging the 911 caller to do. Get here. He's still here. He's still here. You can find him. He's got to go. He just shot him in the head. He was begging the police to find that man, the defendant. Theodore Cameron wasn't saying, oh my God, that guy looked really scared. You better go try to find him and make sure he's okay. He's saying, find him. I'm a person that just saw a man's head get blown off in front of me, and I want the person who did so found and caught. And he couldn't because he ran. And then he ditched the weapon. And ladies and gentlemen, we talked about a lot of things in voir dire. We talked a lot of things in voir dire. One thing we didn't talk, that defense counsel didn't mention, was that we also mentioned that your verdict has to be based on this case and this case alone. The defense, with the way they present their argument, is like a Chicago Bears fan talking about a quarterback. They'll talk about anything else. They'll talk about running backs or the 85 Bears defense, but they won't talk about what you're actually talking about because they don't have an argument. We bring up other cases. We bring up all sorts of other things. We bring up other things that have happened outside in some other place. Let's talk about here. Let's talk about what he did. Some injustice that you may feel that happened in some other case does not excuse or allow or invite an injustice in this case. What the defendant did was homicide. All of the elements have been proven. It was not self-defense. Ladies and gentlemen, even if, yes, withdrawal and he provokes, that doesn't mean he then is automatically in self-defense. A man comes up with no weapon in his hands, and ladies and gentlemen, be absolutely clear about that. This leaves just a few specks. The weapon, the knife, has no blood on it. No one says that knife is out. Not one single person says this is out. Defense counsel spent 35 minutes talking about a knife that's in a pocket that nobody sees come out. And says that is what makes it self-defense. Well, ladies and gentlemen, let's take a look at what defense counsel is saying. Your Honor, could you give me evidence control quick? Ladies and gentlemen, defense counsel is saying that the defendant was acting in self-defense because someone approached him. Someone engaged in his personal space. Someone had their fists up. Someone had a weapon that nobody sees. Ladies and gentlemen, at 1 minute and 26 seconds into this, all of those things apply to the defendant. He's got a firearm that nobody sees. He's engaged and invaded Jason Cleereman's space. He pulls his hand back. He's engaged in violence. He has violence intent in his heart. He's going to punch him. And if Jason Cleereman shot and killed the defendant right then and there, oh my God, would there be a different sort of circumstances and arguments coming from the defendant. It'd be a different super team of lawyers. I'd still probably have to run all their equipment for them, but it'd be a whole different thing. But you know what wouldn't change? Your verdict. Your verdict wouldn't change. Because at this moment, ladies and gentlemen, It's not self-defense. Bringing the identities and characters of who people are in an attempt to influence your verdict just goes to show you don't have an argument. If Jason Cleereman had shot and killed the defendant at that point, I would be here arguing the same thing, that he is guilty and the defendant is guilty. There was no weapon. There was no imminent threat of death or great bodily harm. He started a fist fight and then he ended it with a bullet. And I am just glad that finally at the end of this, the defense is willing to admit that the victim's wife loved him. Because for 2 or 3 days we were hearing about purportedly loves and why didn't she do CPR and oh my God how cold she is and oh why didn't she get the wallet. She told the officers right at the beginning, it's on the body cam. She was asked on the stand, she got the wallet. The knife never came out. The defendant shot and killed a man with his hands up, worst case scenario, in a situation in which Jeffrey Parr states he shoots an unarmed man, in which Jose Perez states he shoots an unarmed man, in which Rodrigo Cameron states he shoots an unarmed man, in which the video shows he states and it shows that he shot an unarmed man, in which Evangelina Cleereman states that he shot an unarmed man. And keep in mind, defense counsel stated that she heard the defendant give a warning. No one hears that. Not one person. Not one person hears any of what the defense counsel is trying to say the defendant heard. Nobody hears it. Because it didn't happen. It just didn't happen. He started a fight and then he killed the man. Every portion and escalation of violence came from the defendant. Words, I'm going to punch you. You want to punch me? I'm going to shoot you. And ladies and gentlemen, when you go through all of the elements like I went through with you and the defense avoided, you find that he's guilty. Negligence out. But I do think you should at least keep in mind one thing. Defense counsel spent about a half an hour trying to explain away his own client's words. The defendant could not have been more clear. He says the gun is pointed down. He states that the victim is lunging at his gun, by the way, or about to spear him, and the gun goes off. That's his words. Not, I shot in self-defense, not, I was trying to keep him away. I stepped back and the gun goes off. That is what he said. And defense counsel spent half an hour trying to make it seem that that's not what his client said. That is what his clients said. Because when that last-ditch effort by the defendant doesn't work, now the defense counsel's got to try Plan Z. Running didn't work. Ditching the gun didn't work. Lying to Kentucky didn't work. Lying to MPD didn't work. Lying to you didn't work. And now we got a whole nother plan. This case is what happened right then and there. And on that video, there was not a lunge. There was a step. Rodrigo Cameron says he has his hands up. Other people didn't see it. But regardless of it, the worst case scenario is a person who got punched was getting ready to punch back. And the defendant shot him. That is first-degree intentional. If you think he actually believed that there was a threat of death or great bodily harm, because that's what he has to believe, then it's second-degree intentional, because there's no way that's reasonable. If you think that maybe shooting only once somehow is not intent to kill, even though he's a trained weapons guy who's got a gun and at close range puts one into someone's brain, then it's first-degree reckless. If there's utter disregard for human life, if there's not, it's second-degree reckless homicide. Everything defense counsel just went through in terms of their arguments does not get you to not guilty. It's just a matter of which one of the homicides he's guilty of. Because there was not a valid self-defense claim here. Ladies and gentlemen, when you go through it, and you go through everything, regardless of whether or not they went and found something at Glorioso's, and keep in mind, defense counsel made a big deal of all this video, only to find out, and not mention at all in their closing for some reason, that the defendant says it's even further eastbound than that. Who cares about the swerve on video? It wouldn't have changed what happened when the defendant pulls a gun and shoots the victim. And their whole point for why that matters is Ricky Burns. Keep in mind, you are taking and hearing someone criticize an investigation in which they are doing everything they can, and he and they cherry-pick the evidence, cherry-pick the result, and Ricky Burns never asked for anything more. There were reports he didn't see and didn't even care to see. Why? Because they didn't want him to see them, because it didn't help what they wanted him to say. Talk about showing everything. They didn't. We called all the witnesses. You've heard all of the case. This is about this case and nothing more. And the simple fact that anybody tries to draw your attention to something else goes to show that they know they can't win when it comes to the elements and the facts in this case. He's guilty, ladies and gentlemen. The facts are clear. The law is clear. He's guilty. Your verdict is clear.
Thank you.